one and all. We are honored to have with us today His Lordship Honorable Mr. Justice K.R. Shriram, who will inaugurate the BBA IATC training program. This is the third year of this training module created for junior members of our bar. May I request Mr. Nitin Thakkar, our President, to kindly address all our members and welcome Justice Shriram in our midst.
The Honorable Mr. Justice Shriram, the trainers and the trainees, friends, ladies and gentlemen, a very good evening to one and all. Clarence Darrow, a celebrated American lawyer, once famously said, "The only real lawyers are trial lawyers." One would feel that this cannot be true in the present day, but believe me, it is true even today. It is trial experience that builds fundamentals of lawyers, and that is what this course aims to do. It gives me immense pleasure to welcome Justice Shriram for the inauguration of our third trial advocacy course. It is an honor that your Lordship has accepted our invitation spontaneously and graced the occasion to bless our budding lawyers. From today, we commence our first physical course in trial advocacy. The earlier two courses were held online. Since this is the first course that we are conducting physically, your Lordship's presence has made this occasion more memorable and monumental. To my young friends, thank you for joining in this course and availing this opportunity. I envy you because I come from that era when there were no classes and there were no courses, there was no training, even there was no Evidence Act in my curriculum in Government Law College where I studied law. We were raw and were thrown in this vast sea and were required to survive. We saw other stalwarts performing by attending the courtrooms where trials were going on. We observed Mr. Ram Jethwalani in election petition of S.K. Patil and George Fernandez in courtroom number 37. We saw Mr. M.P. Lord, a great cross-examiner of his time. We saw amongst others Mr. Fali Nariman, Mr. K.S. Cooper, Mr. Mahendra Shah, the list is endless, conducting trials in courtrooms here. As juniors, we attended proceedings and watched the masters at work. We also had the opportunity to study their body language, how they were able to ensure that witness doesn't avoid the question, and most importantly, how they knew when to stop. We learned as we watched and we tried to put it to good use when it was our turn to conduct a trial. You are all very lucky, and I am glad that you have grabbed this opportunity. During COVID period, when the lawyers were undergoing challenging times, one of our members, Ms. Namrata Shah, brought the proposal from the International Advocacy Training Council that they were interested in affiliating themselves with the Bombay Bar Association. We were skeptical in the beginning. Our first thought was that advocacy is an art. How can it be taught? However, I stood corrected, and seeing is believing. So we decided to go ahead with the course. We found that while the art of advocacy lies in all of us, it is this course that will keep fine-tuning it. Knowing that a course of this nature can benefit juniors, who are the future, assures me that although circumstances of learning have changed, the quality of lawyers doesn't need to. We got our own faculty thanks to the first course, which was mainly to train trainers. I welcome and gratefully appreciate the time our faculty has devoted selflessly. I thank each one of the trainers. Sir, our enthusiastic team of trainers are aiming to conduct at least 3 courses before summer vacation next year. Good luck to them. I must take this opportunity to announce that the value of this course is being recognized by other jurisdictions in our country. Today, in the whole of India, the faculty of the Bombay Bar Association can boast to be the only faculty to be trained in trial advocacy by the International Advocacy Training Council. Acknowledging and appreciating this, our faculty has been invited by the Goa Bar Association to conduct a course in Goa for the juniors, and this is being arranged on 8th and 9th December of this year. And this has been possible with the initiative taken by our very own Akash Rebello, and kudos to him for facilitating this alliance. This December, 8 members of our faculty and 2 members from the Malaysian faculty will be visiting Goa to conduct this course. I wish them all the best and hope that this is the first of many such associations. In conclusion, I urge young lawyers to use this course to their full advantage. Our faculty is dedicating their time and efforts to train those that will one day be their competition. May their selfless training benefit you, and may you all have a successful future in trial advocacy. Thank you very much.
Thank you, Mr. Thakkar. May I now request our committee member and chairperson for this group, Mr. Farhan Dubash, to present to His Lordship Justice K.R. Shriram a small token of our affection. Before we call upon Justice Shriram to address all of us, may I request one of our members, Ms. Mahek Bukwala, to give a brief background about this year's module and program for all our members.
My Lord Justice Shriram, Mr. Nitin Thakkar, President of the Bombay Bar Association, Mr. Vishal Kanade, Secretary of the Bombay Bar Association, Mr. Farhan Dubash, Chairperson of the BBA ATC, members of the bar, my dearest faculty members, and all the participants for the Third Advocacy Training Course. Welcome. It gives me so much joy to be before you all and tell you all about the joys of being a part of the Advocacy Training Committee. I'm obliged to my Lord Justice Shriram for gracing this occasion with your Lordship's presence. It encourages us to do better, to be better. I'm also grateful to Mr. Nitin Thakkar for giving me this opportunity of addressing this wonderful audience. The International Advocacy Training Course has been founded by the International Advocacy Training Council, an organization registered in Hong Kong. The aim of this organization is to spread advocacy training to different jurisdictions. The method used by the organization is known as the Hampel method, which is a 6-step program devised by one Professor George Hampel of the Australian Bar. To be able to train using the Hampel method, first trainers themselves receive training. In November 2021, when this course was proposed to the Bombay Bar Association, with the permission of the then Chief Justice, members of our bar received online training from different senior trainers internationally. The international trainers comprised of sitting judges, senior advocates, and advocates from countries like Hong Kong, Singapore, Malaysia, England, and South Africa. After 3 days of rigorous training, the first BBA ATC faculty was born and had 19 members of our bar. When I was asked to be one of the trainers, and I must brag that I'm part of the first 19 people forming part of the faculty, so I've been with the course since its inception. When I was asked to become a trainer, the first thought was anxiety, nervousness, which I'm sure a lot of the new participants may be feeling today, because suddenly, where I was in this comfortable place in my practice, I was going to be judged by a complete foreigner who didn't belong to my jurisdiction and who was going to not only tell me whether I had the skills of advocacy, but also whether I was capable enough of training. It made me feel vulnerable and powerless. It is only after 3 days of intensive training that I realized what a privilege it had been to be able to learn how to train. It may sound cliched, but my approach to advocacy has changed much after becoming a trainer myself. My actions in court are more deliberate and more thought out, and not the chalta hai attitude that we're all used to when we go in a courtroom. There are times when I finish a matter, walk out of the courtroom, and think that if I were to review the mehek that just argued that matter inside, what would be my points that I would give her? And this is the very same thing that brings us all together, the pursuit of becoming better, whether we are members of the faculty or participants. In December 2022, it was decided to expand the faculty. This time it happened in person, where trainers from around the world flew down to India and held training programs in the courtrooms of the Bombay High Court. Today, the BBA ATC is proud to say we have 40 members of the BBA as trainers. When we opened registration for this course, we were overwhelmed with the response that we received. We had only 60 seats, but within the first 24 hours, we received more than 100 responses, and we had to shut down the form prematurely. This course is going to give all the students a hands-on training on how to conduct examination in chief, cross-examination, make submissions in an interim application, as well as the final hearing of a suit. The course materials on which the training is based is standard world over, but has been adapted to our jurisdiction. Organizing this very course has been so much fun. I want to take this opportunity of thanking Mr. Thakkar and Mr. Kanade for pandering to all my demands when all I did was call them up at the strangest of hours. I would also like to thank our chairperson, Mr. Dubash, for giving me the autonomy of running the course how I deemed fit. And lastly, I would like to thank my friends and fellow trainers, Mr. Firoz Bharucha and Mr. Akash Rebello, for lending me the helping hand that I didn't know I needed. The enthusiasm from the faculty and the students is incredible, and I can't wait to see what the next few days hold for us. I hope the bonhomie amongst us all continues, and I do endeavor to make the BBA ATC faculty one of the finest in the world. Thank you so much.
May I now request Justice Shriram to kindly address our members.
Good evening, everybody, and thank you to Nitin Bhai and the Bar Association to invite me to inaugurate the Third Advocacy Training Course. I don't need to go into everything else because they have all spoken. The session is how to prepare for and conduct examination in chief, cross-examination, and effective oral submissions. A lady dies. She's a mother. Her son's friends write to the friend, "Oh, my condolences to you. Your mother has died. She was such a nice person. She was, whenever we would come to your house, she would treat us so well that she was like a mother to us, to me." Then a man dies, so his son's friend writes to him, same condolences. "When we go to your house, your father treated me so well that he was like a father to us." A brother dies. He writes, "Your brother was so nice, he treated me like a brother." But a man's wife dies. You can't write saying, "Oh, whenever we came to your house, your wife was so nice, she treated me like your husband." So what I'm saying is, though you all are going to be trained in this very well, there is no straitjacket formula. Each matter has to be handled separately and the way it has to be. what I thought was I will tell you few of my experiences as a lawyer, and perhaps that could give some hint to the young lawyers who have joined in the training program. First of all, there could be cases when you get a brief that, let's take it, I was a maritime lawyer and I can speak from my experience, and it's really lovely to do that. If there is a collision somewhere, pre-litigation investigations as a lawyer, if you go and do it, because that's where your trial, everything begins. You go around, and I'll tell you, I have gone on ships, I've gone around ships to see what has happened. I've spent time on board vessels to see how containers could have fallen down, how this collision happened, etc., etc. So when you go and do the first pre-suit investigation, you get to know firsthand what has happened. And when you do that, you also interact with the persons who were at the site when the incident happened. And that will help you decide who all should be your witnesses. And because that is where the whole thing starts. It's not like filing a suit. You're not going to be doing an interim application. A trial is something very, very serious, because what you start at that stage is where you're laying your foundation for the benefit of your client. Then comes, after you finish, what that stage itself I would suggest, the young lawyers, is to make a list of those persons whom you feel would be able to give you first-hand information on what the incident happened, how the incident happened. You call them, record their statement in an affidavit in the form of how you would, it's like a statement recording, like I have done. There was a ship which floundered here, went off the ONGC rig. I spent 8 days with the crew members, asking them what happened. From the captain, there were some 23 crew on board the vessel. Each one was interviewed because each one was on board. Because what is very important is who you represent. I was representing the owner, because after I speak to them, the first person who is going to come there are the insurance surveyors, the P&I surveyors, then the Mercantile Marine Department surveyors. They are going to see what really happened, how to fix the owner. And that is the stage which you will learn. Never can you tutor a witness. The moment you tell them, because you know you don't want them to say certain things to the insurance surveyors because your client's claim could get jeopardized, or to Mercantile Marine Department investigators because there could be certain other implications or complications with that. So what you should do at that stage is, if they give you an answer, you say, oh really, why could it not be like this? So they say, yes, that could be. So I wish say, what is more possible, which is more probable? So they say, yeah, this is probable. Then why did you not say that? So they have got the hint, and the idea was what to say. You don't tell them, say like this to the insurance company, then they start thinking. So you are actually training them how to give evidence, make their statement. Then comes, you will file a suit. I would suggest once you file a suit, you would serve the summons, serve a copy of the written statement. Nowadays, we only see after the court starts cracking its whip that you start preparing your affidavit of documents, and then draft 10 adjournments, and then you start framing the issues. What you should do, the first thing first, is at that stage itself. This is for the young mind we are training. Others are all too set, it's difficult to change. The young minds, what you should do is, as a lawyer, if you were on the other side, what would be your defense? So based on that, list out what all could be the possible issues, and then start recording what I said in the beginning, evidence of, you can just prepare statement, need not be in the affidavit form, because you will have the details of the witness whom you should summon when the trial starts 10 years later. And secondly, it's fresh in their mind. You get fresh information for the trial. And then you prepare the list of witnesses whom you would want to, because with that you know with all details so that you can contact them even after they leave their job. Record all this. Then comes, after the written statement is filed, issues are framed, then comes the stage of filing your evidence in chief. Before that, you need to strategize how to take your case forward. It's not just you take the plain, convert it into first person and then start and file it as examination in chief. And I'll tell you with my experience, that is what has happened. We have seen examination in chief evidence saying drawn by and settled by. We have seen examination in chief which says in rejoinder to the written statement filed. We have seen examination in chief dealing with jurisdiction clause and limitation clause, cause of action, etc. Please, how would you as a witness step into the box and give your examination in chief? That is so simple. That is what you should put in the examination in chief, so that nothing but testimony should be found. We have seen points of law raised, jurisdictions, arguments are raised in evidence affidavit. I'll tell you an example, even because what you put in the evidence in chief, because that's how you're basing your whole case. You're proving your case, your claim. But the moment you put things which could demolish the evidence, you're lost your matter. Tell you, for example, if a person is a witness of fact, why should you have in his evidence what the points of law is? Now next, going into cross-examination, because in one case, it was a case on a claim for bailment, deficit in sale proceeds. The port had received the cargo from the ship. Nobody came forward to clear. Port had to sell after some years. After selling, there was still a deficit in sale proceeds which it had to recover. So it was suing for the deficit in sale proceeds from the owner stroke the agent. And in the witness statement, it was said that I so and so, and this was a case of bailment, and we were the bailors, he was the bailee, etc., etc., etc. And then matter is dealt with. So in cross-examination, see, again, you don't have you'll have to change depending on the witness. You'll have to change on what the answers come. So the witness said, oh, I'm only a graduate. So how did you start your career? He says, I was an accounts clerk. Then I went to the stores, then from here to here, etc. I said, are you a law graduate? He says, no. Would you know anything about law? He says, no. So could we assume that you have, it's all in cross-examination also when you do, you can lead the witness to the answer you want to. Could we assume that you have a law officer? Yes. So your lawyer drafted this affidavit? He said, yes. Your law officer okayed it? Yes. And he told you naturally that now it's ready for you to sign? Yes. So you agree that it was your law officer who has prepared this affidavit? Yes. So please tell us which are the parts in your affidavit has been prepared by the law officer. He said, except solemnly affirmed, everything else was by the law officer. So the entire evidence got demolished. In another case, and when you cross-examine, I should tell you an incident when I was like many of you. Courtroom number 2, where Justice Variava used to sit when he is sitting single 2 before that. Before he went to 3, he was in 2. When the Jai Hind Oil Mills case was going on. And one of the public sector bank's general manager was in the box. And the inimitable, the greatest, Ramjit Malani was cross-examining the witness. Thankfully, he was not very tall, and I was standing behind him and then peeping into, because he was asking question after question, and I was looking at, he had some scribbles on his paper. I was looking, how is he doing it without any questions written? So at lunch break at 2 o'clock, I said, "Sir, pardon me, may I ask you something?" He said, "Yes." And I said, "You were asked cross-examining, but I did not see any questions written. How did you ask so many questions?" He said, "If I write questions, then I'm joking, not cross-examining." So I said, "So then how did you do it?" He said, "We write the answer, we want to hear from the witness." And that's what I went to the chamber and spoke to my senior, and that's what I realized later when I started working with him, that write the answer. Because what happens is when you write down about 100 questions, you ask question 1, question 2, question 3, question 4, and you go on up to 100. But there will be many situations after question 4 you may have to ask 4A, 4B, 4C, 4D, which you have not written down. And you will miss out, and that could make a difference in your case. Because you have not confronted the witness on what he has said so. So therefore, what you should do is, you must not put in your evidence which the witness is not capable of answering. Because you have to be very, very careful as to what you say. Even for example, I'll tell you an incident. I did criminal appeals. In one matter, it was originally the lady was shown, it was against acquittal, and it was 22 years, there was nothing much to be done. I found the initial charge was murder, and then later it was converted to suicide, because that's what the autopsy reports, everything said, because the ligature marks were oblique, not flat. But my own take on that, applying our own, we all have something between our ears, that even if you choke somebody and someone is sitting on the floor, you lift them, there could be ligature marks. It need not be a suicide. And the evidence said that she committed suicide in the bathroom by hanging somewhere in some remote village somewhere. Even in any city, you don't have bathroom of standard size more than 8 feet high. And in bathroom, maximum you will have is a shower. You don't have a fan hook. And the lady's height, I noticed. I'm telling this because these are the details which you need to look into. You all have to gather as to what all you have to look for when you are doing a trial, how your mind should work. I'm not telling you what you should do. It's only food for thought. The lady was 4 feet 9 inches. I looked at the bathroom plan, it was 5 feet 6 inches. So I said, when you hang, you need to have some kind of a gap for the noose to hang. And when you hang, your feet goes down. Your feet will be touching. So for the lady to have committed suicide with her height, overall height, and the height of the ceiling and the floor, it's not possible to die, to hang. Perhaps she stands on a bucket, kicks the bucket, and then folds her leg. She could have hung. But there is nothing to indicate, no evidence to indicate that there was a hook which could take her weight. And the evidence did not, police reports did not say that her leg was found crossed, or the photographs didn't indicate, because once you have died, it's very difficult to take your leg, make your leg straight. So these are the points which you need to keep in mind when you're doing a trial. It's not just reading the papers. You have to think more than what your case file talks about. And examination in chief, I have to go to the cross. Law officers today, I find in every matter, every client, unfortunately or fortunately, they have all legal department. And the operations say this is a legal problem. It's for them to answer the court. It's for them to answer the lawyers. But the law officers don't know anything about operations, what really happens. And they end up becoming not a very good witness. So you need to use them maybe to set the ball rolling until you work out. If the judge pressurizes you, file your evidence tomorrow, use them to just, like a night watchman, keep going. I knew of one counsel I wouldn't name once before Justice Penche. At 4 o'clock the matter reached and Justice Penche said, I'm not granting an adjournment. Start. Maybe if I tell what happened, you all can guess. At least Nitin Bhai would and Mr. Bukwala will. Lordship will read the plaint. See what the paragraph 1 says. What paragraph 2 says. He keeps on reading till 4:45 and next day he prepared and came and argued the matter. So in the when you cross-examine a witness, there is no question of referring to the papers. I'll tell you, everything has to be here between your ears. You must have it soaked in totally. I'll tell you an experience when we were going to cross-examine a witness in a total loss claim against the underwriters. I went and told my senior in the evening that, sir, tomorrow 11 o'clock you have to cross-examine. When do we have conference? He said, okay, 10:30. I said, 10:30 we have to be starting at 11. I said, 10:15. And he walks in at 10:30. So I said, so when do we start? Come, we'll talk in the car. So we got into the car and he said, who is the witness? What has the witness said? So and so, so and so. What's your answer for this point, this point, this point? I said, you have all the documents and cross references to the other witness statements? Yes. All on your fingertips? Yes. Come, let's start. And with that conference of 8 minutes, he cross-examined the witness the whole of that day and the next day, half a day. The thing is, you know the subject, you should soak it in. And I'll tell you an incident that in that case, the defense was non-disclosure of a material fact. The insurance company can repudiate the claim. The agreement, had an addendum. The forwarding letter for cover said, agreement is enclosed. And our stand was, agreement includes an addendum. And their case was, only agreement was given, not the addendum. Now, how do I prove that the addendum was also part of it? Frankly, I didn't know how to do it. My senior said, relax, we'll find a way. So they got their branch head to whom this the proposal was submitted. So I'll just tell you the line of questioning that happened. He said, how many policies? In short, how many policies you issue in a year? About 300. So how many of high value, low value, etc.? He says, all are the various kinds. So you put everything in separate files? He said, no, all are put one behind the other in the reverse order. Do you index every file? He said, no. Do you paginate every document? He said, no. So if some paper falls off your file, would you know? Because once you issue the policy, then it remains in the file. You would never go back. Why should you go back? You take, so long as your premium keeps coming. He said, yeah, I agree. No further cross. And he argued on the probability basis that this is what he has not denied. So I'm just telling you, these are the things which you could keep in mind. Another case of vessel loss. It was a maritime casualty and marine inquiry was going on. We were representing a classification society, and one of the earlier masters had filed an affidavit saying the vessel was unseaworthy. So how do we deal even? I mean, I was quite young and I didn't keep quiet, we will take care of it. So why, the one point you should keep is you should know the subject thoroughly. You must sit with your client, understand the whole subject, what happens. Again, going back to not reading the file, not just reading the file and the plaint and the written statement, can you really prepare for doing a trial? You have to soak it in again, I'll tell you. So he said, Captain, you're the big boss. He said, yes. Everyone is under you. You know, again, when you'll have to have voice modulation in your cross-examination. You should, like Nitin Bhai said, or you said, you'll have to read the body language of the witness. What kind of a person? Is he full of himself, or meek, or someone who is ready to just finish and go home? You know, you need to read the witness correctly and then cross-examine the witness. So he said, I'm the big boss, so everybody is under you. So what happens? You have said, if the hull of the vessel is thinning, who goes and checks? Naturally the engineer, because you're the big boss, you're the master of the vessel. He said, yes, the engineer goes, and engineer checks. And you did not go with the engineer. He said, no, that's the engineering department's job. He said, yes. So the engineer came and told you that the plates were thinning. He said, yes, no further cross, point over, because that becomes hearsay evidence. You should know what to do and when to stop. And then we knew under the Merchant Shipping Act, if a master has taken an unseaworthy vessel, he'll be hanged by the government. His license will be gone. He will never be able to command a vessel again. So the moment we said that, he says, no, I will never take an unseaworthy vessel to sea. No further cross. So again, you should know the subject very well and then work on the matter. If you're doing a matter relating to the stock market, you should know how a broker functions. If you're going to do a matter relating to funding on which some share certificates are pledged with you, how the industry works, how much time, whether 1 day notice is enough or 48 hours notice is required to be given before you invoke the pledge. These are the points which you need to keep in mind. And who should be the witness? There was a matter where a very senior government employee would have been the best witness we could have. The client said, sir, give me 2-3 days time, he has just resumed. So I said, what happened? Some problem, 3 months he was under suspension. I said, for what? So he said, there were some allegations. I said, we don't want him because he'll be the worst witness. And many a times I have seen during cross-examination, the junior most from the office is sent, you just keep a watch what's happening. But the junior most should also be ready to raise objection at the right time. There was a matter where an unexpected question was asked to the witness in the same matter which I referred. Are you going to bring the said person as a witness? Nobody even thought such a question will be put. So objection was raised that who should be a witness shall be the lawyer to decide. And there was, no, let him answer. Why are you saying? The witness was smart. The witness said, I'll answer. That my advocate will decide whether he will come as a witness. So these are things which you need to do not take any of this very lightly. Even re-examination really matters. It's not just for a matter of course. And re-examination also, the witness can be cross-examined. So these are the points which you need to keep in mind. And finally, coming to arguments, you should have it here again. See, the reference are only points. You need to have bullet points, but the rest everything, you need to expand on it. You have to be, Justice Patel has issued passed an order how you must keep the documents and the pleadings for trial. I have added a bit to it. That should be the template for you all to work and be please, every time we start a matter, the exhibits are not marked. Because there is a difference between exhibit 1 in the plain and exhibit P1 and D1 in the, or what is X, what is Y, means you have to prove. How to prove a document? There could be situations where you will not have the original document, you will not be able to prove it in your evidence, or you might have missed out. You can bring it through the other side's witness. Keep that in mind while confronting him with a document. So having said all of that, and there is no chalta hai in any court, okay? At least in 2 courts I can say chalta hai doesn't work. One of is yours sincerely and somebody, Justice Patil's court for certain, and many other courts. So wish you all the very best, happy training, and for the trainers, I'm glad we are having such a program because this prepares you all for the future. But keep in mind, there is no substitute to hard work, and keep in mind that court is serious business. It's not a place to have fun, and clients depend on you to get them justice. You will have to live up to that. Do not break or breach that faith and hope they repose on you. Thank you very much, and I wish you all the very best.
I would like to sincerely thank Justice Sriram for having accepted our invitation and for inaugurating the third BBA ATC program. His Lordship recounted his experiences. I am sure all our members, participants will benefit immensely from the insights that he has shared today. Thank you all the participants for being part of this training program. This concludes our function. May I request all our trainers and senior members, standing committee members to join us for snacks. For all our participants, we have arranged snacks for you in the corridor. So before you move on to your courtrooms for the sessions today, please help yourself and we'll start in some time. Yes.